Missing Bill. That hit the night international.
It's one of those mornings, last meeting of the year.
I told him if he didn't get back, coach will give him some votes if he votes on that motion, that was better.
Yeah.
He probably was kidding.
No, I said. Well, you were gone. Yeah, because I'm.
Sandy, I'm trying to.
Yeah. We expected it. Yeah. Part of that.
I'm not surprised.
They'll
still get paid though.
I was thinking this last one.
You didn't make it a season.
Well, as my husband would say,
Team
you
game.
get a much better record.
It's like a number. That's team.
When you won the-
Okay. Where's our friends?
Yes.
Okay.
Morning. I apologize.
I had it yesterday. I was supposed to get Wow. No, personally, right. I gotta make everyone else that said they wants to sign up. Good. If anybody would like to, I mean, there was a sign up sheet there. If anybody wanted to be prepared to speak to the commission on a particular issue, you can sign up. Chris, if you want to say that. Here. Okay. There may not be. All right, I'd like to call the December 16th, 2021 meeting of the Ohio Elections Commission to order. Ricker, if you could please take the roll. Ms. Cunningham?
I'm here.
Mr. Norman? Here. Mr. Brommer? Here. Ms. Barnes?
Here.
Here. Vice Chair Beatty? Here. Chair Presence? Here. All members are, all right, all set and present. Very good. First item on the agenda this morning would be approval of the regular meeting minutes of December 2nd, 2021. Everyone should have received copies of those. Are there any additions or corrections to the minutes? If not, I'll entertain a motion that we approve. We have a motion been made by Charlene, seconded by Ms. Barnes was not present on this.
Oh, I'm sorry.
Mr. Norman, I heard Mr. Norman. Mr. Norman is.
Mr. Brommer.
Why would it?
Oh, you did. I thought you did.
I'll
Sorry.
Thank you. All right, we now have a motion that's been duly seconded. Thank you, gentlemen, ladies. Further discussion. We do look alike.
Exactly.
It's the end of the year. Both their class. All in favor of the motion to approve the regular meeting minutes of December 2nd, 2021, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 6-0. There you go. Some are abstention. Next item would be approval of the regular meeting minutes of December the 7th, 2021.
So moved.
Do we have a second?
Second.
All right. All
That you can do.
Thank you very much.
all in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Please note my abstention.
And I wasn't there.
Correct. Both are reflected.
Two abstentions. Very good. All right, moving on to preliminary reviews. First case on the agenda this morning is case 2021 G-019 Cross versus Ganari. Mr. Richter.
Mr. Chair, members of the commission, the complaint legislative responded failed to include the proper disclaimer on some correspondence that he properly solicited, and solicit contributions on public facility at a time when public work is taking place. Respondent's counsel responded to the complaint, states that his client's correspondence was personal, and that there is an allowance in the complaint for personal correspondence not to have a disclaimer on it. Further, there was a door hanger included with any material that did have a disclaimer on it. And so the other allowance in the statute is that there is a multiple piece mailing made, and one piece includes a disclaimer that is appropriate. Further, the second allegation was made based on anonymous tips, and there was no factual basis that was included on which the commission can rely. Based on the complaint and the response, my recommendation is to find no violation and dismiss. I don't know if anyone's here for that particular case.
Counsel for the complainant or the respondent present, or the respondent of the complainant person. Thank you. Any witnesses? All right. Questions of Mr. Richter? If not, I'll entertain a motion.
I know that we find a violation.
We have a second to the motion. The motion's been duly seconded to find no violation and dismiss. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Next item on the agenda this morning is case number 2021 G-021, Ford versus Anti-Corruption Act et al.
Mr. Chair, members of the commission, the complaint here alleges that the respondent, and I have it incorrect. Oh, see, there you guys should consider what I've done, because that's a mistake. Reference there. The respondent's package should have, now I can't remember because I copied and pasted, and anyway, I should let Mr. McTighe is here on behalf of the complainant. That I know. If you looked in the file, there were no green cards included in the file, but I did check on service with the United States Postal Service. And it reflected service on the respondent committee, but it did not reflect at the time service on the treasurer for the committee. Two different addresses were listed. Let's see what I reflected here. That was just for this case. Anyway, so I believe we do have good service. Oh yeah, but the commission's materials were delivered on November 4th to the address of the PAC. We have not yet received the return for the treasurer package and server. Like I said, Mr. McTighe is here. His complainant asserts that, that's it, that the Anti-Corruption PAC is a federal political committee and never filed its statement of organization with the Secretary of State's office, which would allow it to take part in an Ohio election. 3517.107 allows for federal committees to participate in any local or statewide election, as long as the statement of organization is filed. And so my recommendation is to find a violation and impose a fine of $25 per day with reconsideration option until the statement is filed. Certainly, if the commission would hear from Mr. McTighe, it could have done so.
I have a question before you vote. How, I mean, are you bifurcating? We don't have service on one of the defendants, right?
Well, we do have it on the committee, and the treasurer is the treasurer for the committee. And we could bifurcate though if we wanted to do so.
And it seems that we may be continuing until you actually have service
Yeah,
on the
you
treasurer.
have to have service on both.
So they can adequately respond.
So you can't, it keeps falling against somebody who hasn't been served.
Right.
I don't know how you proceed without service on both defendants. And they're different addresses. Services at different addresses.
So do we continue then?
I'm going to continue.
That's
We have a motion, Tim was
here.
all right, we have a motion that's been seconded to continue. Further discussion on that?
Is there anybody here for, I guess, we should
Mr.
ask,
McConaughey is
for the
on.
treasurer? Is anybody here for the treasurer? Or have they appeared?
Anybody here on behalf of the PAC?
Anybody?
Oh, we know Mr. Tag's here.
PAC.
With them. Mike.
All right, we have a motion that's been duly seconded. Go ahead and continue this matter. All in favor of the motion, signify by saying aye. Opposed, same sign. Motion carries 5 votes to 0. Matter's been. Sorry, Mr. McConaughey.
Merry Christmas.
I look forward to seeing you next year.
Okay. Next case on the agenda this morning is case 2021 G-022 Chambers versus Blystone et al.
Mr. Chair, members of the commission, complaint that alleges the respondent failed to properly reflect all campaign contributions and campaign finance reports. His response was submitted, which was circulated to all of you to the allegations, along with a request for a hearing from the council. Initially, as I indicated to you, the commission received a request for continuance for the preliminary review from the council for the complainant, but that was subsequently removed. My recommendation is to set the matter for hearing. Mr. Tollins, counsel for the complainant, is here, and Mr. Brown, counsel for the respondent, is here. If the commission would like to hear from them.
All right, let's do that. Council. Mr. Collins, would you go ahead and enter your appearance, please?
Yes, thank you. Good morning. My name is Scott Pullins, Ohio Supreme Court number 0076809. I'm an attorney representing Sarah Chambers, the complaint in this matter. As a preliminary matter, I would argue that the respondents have not filed a proper response under oath. Ohio Elections Commission rules require, and respondents have been informed twice by letter, they must file response under oath. A unsworn motion to dismiss filed by an attorney without affidavits from all the respondents, in my opinion, is not a proper response and should be disregarded by the commission. If the commission does choose to consider this motion, I would urge you to find it wholly without merit. It's really clear that this commission has had clear jurisdiction over candidates, campaign committees, treasurers, and other individuals and entities. My recollection since at least 1996 in its present form. More importantly, from our perspective, is nowhere in this response is an actual denial of the allegations in the sworn complaint. There is a separate affidavit from the candidate's wife and treasurer that's full of easily provable factual errors, but again, no actual denials of the allegations. Let me speak briefly to the complaint, if it's the pleasure of the commission. Sarah Chambers was a former campaign manager for the Friends of Blystone campaign. Other persons that provided sworn statements were also key leaders in this campaign. There were some unsworn statements that were part of the complaint, but it's our plan to put those individuals under oath if and when a full hearing is held and if their testimony is needed. We have also recently secured the cooperation of Joanna Swallen, Joe Blystone's former lieutenant governor running mate, who will also provide sworn testimony at a full hearing. Mrs. Swallen withdrew her candidacy and left over these very same issues. To sum this up, the complaint, Mr. and Mrs. Blystone and his campaign committee have taken in vast amounts of cash for the campaign in violation, in our opinion, of many campaign finance provisions. Ohio law requires them to itemize cash contributions that are in the amount of $25 to $100 and file them with their reports. Ohio law prohibits them from accepting contributions in cash of more than $100 per person. Contributions of under $25 may be reported as a lump sum. However, the campaign must still keep records of these contributions. The Blystones allege and reported that they raised approximately $88,000 in cash contributions of under $25. That was over 1/3 of their contributions raised, and we believe they simply cannot and will not document these contributions in any way.
Go ahead, sir.
What they have appeared to have done to us at events after event is to pass buckets around and have people simply throw cash in the buckets. There's no documentation, no donor cards, no limit on how much cash they've taken from an individual. Just throw it in the bucket, and guess what? We report it all as contributions of $25 and under. Mrs. Chambers and the witnesses strongly believe the Blystone campaign has no records whatsoever for these $88,000 in cash contributions that they received and reported as being under $25. They also strongly believe this act was deliberate and have testified with sworn affidavits that it was. Sworn witness after sworn witness have alleged they personally witnessed or they themselves made contributions of over $25, which were never reported. Sarah Chambers alleges that she made contributions not by cash, but through a credit card via their website in excess of $13,000 and has provided the receipts and the bank records to prove it along with their sworn testimony. But yet the campaign has not reported these transactions during the time period they took place. Complaints Exhibit 1 is a video of Dr. Doug Frank making a $100 cash contribution at a public event that was never reported. Since the complaint was filed, we have obtained another video, and we will show it, if possible, at a full hearing of Dr. Doug Frank making a second $100 cash contribution video that was also never reported. Respondents argued these contributions were props. Commissioners, with all due respect, that assertion in itself is a deception and, in my opinion, a clear violation of campaign finance laws. They are also wholly factually incorrect in their affidavit. Doug Frank did not hand Joe Blystone a $100 bill. He counted out 5 $20 bills, and it's all on video. This campaign, in our opinion, can't tell the truth even when they're caught red-handed on tape. We certainly look forward to putting Mr. Frank under oath at a full hearing. Members of the commission, we have videos, we have bank statements, we have multiple sworn witness statements from former campaign officials that illustrate numerous violations of Ohio's campaign finance laws. We believe that we have provided more than enough in this sworn complaint to show that probable cause exists for multiple violations of Ohio's campaign finance laws. At a full hearing, we believe we'll be able to prove these violations of Ohio's campaign finance laws. We would urge the commission to set matters for full hearing, and I'd be happy to take any questions that you may have.
Thank you, Mr. Paul. Any questions of Mr. Paul by the commission? Thank you, sir.
Thank you, Commissioners.
Brown, do you want to go ahead and do your appearance on behalf of the respondent?
Yes, sir. Attorney Josh Brown. Do I have to speak from?
Would you mind? Yes, that did. We can hear it better.
Sure.
For those of us who are blocked by line of sight, it's easier.
I mean, we have nothing to refer to. All right, thank you, commissioners. The first big problem that we face is that the complaint is not acceptable to the commission. OAC 3517-1-02 A1G requires the complaint to reference the statutes that it's alleging were violated. Complaint only references 2 statutes. One of them is 2921.412. That is a theft in office statute. So that particular statutory reference has to be discarded because it only refers to people that are in office. The only other statute that I found referenced in the complaint was 3517-10A4. That is a statute in the ORC that requires the treasurer to file reports and basically requires the treasurer to file those reports accurately. That statute is not within the jurisdiction of the Ohio Elections Commission. Therefore, the Ohio Elections Commission lacks jurisdiction to adjudicate this dispute. The commission's jurisdiction is laid out in 3517.153. References 6 statutes and none of them are 3517-10. There is a reference in there that allows the Ohio Elections Commission to issue a advisory opinion or a legislative recommendation regarding to parts of that .10 statute. So therefore, this complaint cannot be accepted because of a lack of jurisdiction. The OAC statute says shall, and so the complaint is under an absolute requirement to reference the statute. So we would ask that, first of all, that it be dismissed on that basis. If you went through the motion to dismiss that we filed, you'll find that there are basically 11 categorical motions to dismiss. So I'm going to go over some of the most important ones and respond to some of the complainants, the things that the complainant referred to in his remarks. He said that there's no denial. So the affidavit does deny any wrongdoing. And so that's a sworn statement under oath by the treasurer. And then there's the issue of what needs to be denied. So what I'm doing right now is I'm asking you to dismiss on jurisdiction, but let's say you don't want to dismiss on jurisdiction. So now I'm talking about the merits of the complaint and the substance of the allegations made in the complaint. So once we get to that, we deny wrongdoing, and we've done that. Treasurer's done that in sworn writing. We did talk about, in my motion to dismiss, improper parties. The campaign committee is the treasurer. If you look at the definition of campaign committee in the statute, it says whoever receives and expends money for the campaign, and that can be either the candidate or another person. So for this campaign, they have a treasurer. So the campaign committee is the treasurer. So the treasurer's denial is sufficient. That's just the beginning of the argument on that. If we want to get deeper into that, we can. In terms of making sure whether a campaign committee is a corporate or also referred to as a legal person. But I don't want to get too much into the weeds in this presentation here. So there is a law that says that no person can give more than $100 in a single campaign. That law is 3517.13. The problem, now that particular statute is within the jurisdiction of the Ohio Elections Commission. However, the Ohio Elections Commission cannot take up that issue because it's not referenced in the complaint. However, if you did choose to take it up anyway, the statute makes the person who makes the contribution the liable party. Treasurer is certainly not liable because nobody expects a treasurer to go out and be the one at every table, at every event, taking the checks. Nobody expects the candidate to be out at every table, at every event, taking the checks. So the treasurer's only responsibilities under the code are to take the money, deposit it, and report it accurately, and to write checks for the campaign. So the respondents cannot be liable for the $100 limits because the statute makes the person liable and not any other entity. Now, if you read that entire statute, you'll find that there is liability on a campaign committee, candidate, and other parts of that statute. It's one of the only parts of the statute that actually says person. So it's clear that the legislature chose to make the person liable. The $25, that is an exception. So if you look at the treasurer's responsibilities in the code, the $25 exception is 351710B4B. That is a reporting requirement. That is not a gift requirement. That requirement is placed on the treasurer and said the treasurer does, that is an exception to what the treasurer has to report. That is not a requirement on the gifts. So if we're at the table at an event in Newark, Ohio, treasurer's not there, candidate's not there, a volunteer is taking money, the requirement in the statute is not on that event. The requirement is on the treasurer to report accurately. And this is an exception. The $25 is an exception to that requirement. That's why the treasurer cannot be liable for that transaction out in the field. If you're I know some of you worked on campaigns, especially the senator. The treasurer candidate, they're not out in the field always taking those donations. So that requirement is a requirement on the people that are taking the donation. And the treasurer's only job is to take that money, deposit it, report it accurately. And if I really would like those three words to really stick in your brain, take the money, deposit it, report it accurately. That's all that the Ohio Revised Code poses on the treasurer in terms of their duties. For those of you who may have not worked on a campaign, very rarely do you even see the treasurer during a campaign. Treasurer's only duty is take the money, deposit it, report it accurately. Treasurers are very rarely out in the field taking money. And the reason why is because that is their only duty. Take the money, deposit it, report it accurately. There's no testimony that wasn't done. And I will address Sarah Chambers' particular allegation in a minute. That speaks to the buckets issue as well. Treasurer is not responsible for a volunteer going out and placing a bucket out at an event. There's nothing in the code that makes the treasurer responsible for that. There's nothing referred to in the complaint. There's no statute referred to in the complaint. The complaint says they did it. We don't think it was right. This is a generalized accusation with no detail. I want to speak to and getting to that issue, I want to speak to one of my other reasons for asking you to dismiss this complaint, which is this complaint pleads fraud. And fraud in American law has to be pled with particularity. Nobody knows that better than Mr. Kreitz, I know that. So there are two types of rules. There's malum per se and there's malum prohibitum. And it's one of the first things you learn in law school. The reason you have to plead fraud with particularity is a malum per se rule, which means in malum per se, something is made illegal or improper by a rule because it's inherently wrong. So murdering somebody is wrong whether there's a rule against it or not. So that is why murder and the law against murder is a malum per se law. Filling out a form to get your 501c3's tax status is a malum prohibitum rule. There's nothing inherently wrong with getting tax status without filling out a form. It's a rule for the purpose of ordering society. If you look at my motion to dismiss, there is a section in there about pleading fraud with particularity, and it quotes the House Supreme Court and explaining why pleading fraud with particularity is a malum per se offense. It is inherently wrong to plead fraud without doing it with particularity. How much particularity is needed? At least enough so that the respondent can know what the allegations are against them, what rules they violated. In this case, we don't have sufficient detail. That is explained in detail in the motion to dismiss on a case-by-case basis. I said, this is pled with not enough particularity. Here's the things we would like to have had that would make it sufficient to have been pled with particularity. We would like the place, the amount. What did you actually see? What did you not see? That is malum per se. That is by principle and fairness required in the complaint. All right, and then we get to Ms. Chambers' donation, which was referred to in the complainant's remarks. Ms. Chambers admits that she was refunded money from the campaign. She provides no context for the money that she allegedly gave to the campaign. And then she says, this is what was reported. In order to plead with particularity, she needs to explain why that amount that was reported wasn't correct. And her complaint doesn't do that. So it doesn't give us enough information to respond because we don't even know how much she alleges she was refunded. And we don't know what the context was of the money that she gave was. You know, was it an in kind where she was, for example, buying some hot wings for a fundraiser or something like that. And that would make a big difference in terms of the reporting. The treasurer has said, I've reported everything, I deposited everything I took, I deposited it, and I reported it accurately. That's her requirements. That's what she testified she did. So the complainant referred to $100 cash donation with Dr. Frank. Again, the statute would make Dr. Frank the reliable party, not the campaign, because it says the person who makes that donation in the statute. However, there is testimony in the affidavit that that $100 was meant to encourage people at the event to give money, and the money was given back to him. That it was a presentation. There's nothing in Ohio law that requires somebody to report money that you didn't take. Treasurer has to report what was given to her. If that money was never given to her, it doesn't have to be reported. If it was given to a person in the campaign and they gave it back, they burned it, whatever they did with it, Treasurer's not responsible for that. Treasurer's only responsible to take it, deposit it, and report it. Treasurer's not responsible for what happens out in the field. So even if this was a violation, campaign's not liable, treasurer's not liable. Maybe Dr. Frank is, I don't know. Plus, there's a testimony in the affidavit that nothing wrong was done anyway. Another one is there's a video reference in the complaint. We've never seen it. We have no idea what they're talking about. That's classic, not providing enough particularity. There's no description of what happens in the video other than allegedly Joe Blystone takes money. Again, even if it's true, failure to state a claim because Treasurer's not liable for any of those transactions. Now, let's say we ignore all these layers of things that I put in front of you. Let's say the candidate is liable, and there is a statute that says that the candidate should not knowingly take donation that violates campaign finance law. The penalty for that is you take the amount that was improper and you double it, and that's your fine. So we have a first problem is there's no way to calculate. These are generalized accusations. There's no way to calculate what the improper donation was. Even if it was, we're talking about a minor problem if proven. The affidavit for the treasurer says that if there is a mistake, I will correct it. So it's an easily correctable mistake if it isn't a mistake at all. And furthermore, it's a small fine, basically. So as soon as we have proof that there's a mistake, then we'll address it. My complaint, I tried the best I could to make this as easy as possible to read. You'll see I indexed the motions to dismiss, and I also indexed the allegations. So I'm glad to take questions on that. I just want to take a second to make sure I didn't miss anything in my
Takes
remarks.
time, Council.
Okay. Okay, yeah. Last thing, there is even so you don't have to dismiss the entire complaint, you can dismiss counts as well. And so I asked for several counts to be dismissed for one violation or another, but one of the biggest ones is we have a witness in this complaint who isn't even named. And that's a violation of due process because the respondent has a right to confront witnesses even in civil complaints. I referenced the law on that in the filing, but it's also a violation of the rule against hearsay. It's classic hearsay is an out of court statement by someone we don't even know who it is. So the complaint, like I said, throughout has numerous things that fail to comply with the statute. One of them is there are a number of affidavits that are missing, so that can't be accepted. So those have to be thrown out. One big one is the complaint itself, and I wasn't sure at first what I was looking at. I've never seen a complaint structured like this before. So, and being a civil litigator, I look at a lot of complaints and even pro se complaints, and I just I didn't know exactly what I was looking at. If you look at the bottom of the complaint, you'll see that there is a signature and a notary. That's page 10 if you have it in front of you. And at the top, there is a reference of, I'm doing this on personal knowledge. Now, of course, any affidavit has to be done on personal knowledge. And I objected and asked for it to dismissal on the basis there was no affidavit because I saw the signature at the bottom and a notary with no affirmation of personal knowledge, which is required by the statute as well. And then in the response, I saw, oh, at the top of the complaint, there's I'm saying this on personal knowledge. Well, even if that's all true, which it is, it says personal knowledge at the top and it's signed and notarized at the bottom. That witness cannot testify to the things inside that complaint. You can't testify to what other people saw. You can't testify to what other people said. You can only testify to what you saw on personal knowledge. Therefore, the entire complaint must be dismissed because it lacks proper affirmation. I'm glad to take any questions. Thank you.
Thank you very much, Mr. Brown. Questions, Mr. Brown?
And it's a lot of information.
Thank you very much.
Mr. Richter, is anything you've read or changed your opinion regarding the setting of this great hearing?
No.
All right, any other questions of Mr. Richter about the motion? Good motion.
I move that we set this for a hearing.
Give a second.
Second.
Second by Mr. Richter. Further discussion on the motion to set for hearing? All in favor of the motion, signify by saying aye. Aye. Opposed, same sign. Motion carries by vote 7-0, and that will be stepped down for hearing. Thank you very much, gentlemen.
Thank you, Commissioners.
Next matter, case 2021B-025, Paul et al. Versus Brent et al.
Mr. Chairman, Commission, this complaint. The complaint asserts that the respondent did not include this proper disclaimer on certain campaign materials. The respondent states that they filed a waiver that is allowed for any running the vote to be identified as a smaller office, city council under a certain side of the village council, et cetera. And that they did not intend to receive any contributions or make expenditures for the campaign, such as they did. Having filed a waiver, they were not aware that any other disclaimer was required on their campaign materials. My recommendation is to find the violation of the prosecution.
Questions from Mr. Richter?
Do you have anybody here on this issue?
Is anybody here on case number 2021B-025, Culp et al. Versus Brent et al.?
Mr. Richter.
Yes.
Is this the first violation of this campaign?
Yes.
I move that we find a violation, but for good cause on a public fine and refer this for further prosecution.
All right, do we have a second?
Second.
All right, second. We have a motion that's been duly seconded that we find a violation, but for good cause, not of course, fine, but for us. Further discussion by commissioners. If not, all in favor of the motion signify by saying aye. Opposed, same sign. Motion carries by a vote of 7-0. Next item. I'm sorry, it's 2021D-026, Gillespie versus Citizens to elect Wayne Bryant et al.
The chair, members of the commission, this too was a complete, I want to leave that the response to not include a proper disclaimer on their joint, it said joint campaigns, and it's two different signs for two different candidates. When the responses were submitted, the candidate, the respondent for Mr. Bryan, or I'm sorry, the treasurer for Mr. Bryan submitted a response on his behalf. And the candidate, I think it was Ms. Simcox, filed a response. That one was received yesterday, I circulated it to everybody, that essentially said they weren't our sign. We didn't have anything to do with them. A separate person, I think Captain Hall, is who was identified, was the person responsible for the sign. Walsh, thank you. I was about to look and see if I was screwing up the name. Thank you for. Anyway, we also received a response from Ms. Walsh. It says, yeah, those are mine. I did them. I paid for them. I was responsible for them, and the candidates had nothing to do with them. So under that set of circumstances, my recommendation is to find a violation.
Questions of Mr. Rickman? If not, we'll entertain a motion.
Is there anybody here on case number
Oh, I'm sorry.
2021D-026, Gillespie versus the Citizens to elect Wayne Bryant at all?
Yes,
Nancy
ma'am.
Gillespie. I'm Nancy Gillespie.
Oh,
Did you want to make a statement, ma'am?
Well, I did not have all the information about Kathy Walsh providing money for signs, but nevertheless, I thought that the
Let's go
laws,
ahead. Would you please come to the podium, ma'am?
Yep.
Thank you.
I don't have a statement or anything. But regardless of who is,
yeah, would you, please be floor, you can make a statement.
Raise your right hand.
Yeah.
Swear from a child through, hold true for nothing but the true self of God.
I do.
Thank you.
I don't have a statement. I just know that when the signs were posted and throughout the district for the school board campaign, none of them had any information about who paid for the signs. Kathy Walsh is a member of the Groveport Madison School Board. She should have had on the signs that she was the one that paid for the signs. That seems to me to be the rule. That's all I have.
Thank you, ma'am.
Thank you.
Questions?
I'm sorry, I did have a question.
Second question.
Yes,
Was she also running during that campaign?
she was not.
She was not
She
running,
was not on the board, on the ballot.
but she was on.
She was on the board, yes.
Okay, thank you.
You're welcome.
She's not a party before us.
Right. Any other
I
questions?
She is
got
not.
that part, But
And you didn't pay for it,
Pardon?
and the campaign committee didn't pay for them.
I was not part of a campaign committee, ma'am.
Okay.
No, I was walking in my neighborhood when I saw the signs and I thought, I wonder who's paying for those? And so I went to the sign and it didn't have anything on it.
Okay.
By rule, I thought that was required for campaign material.
Thank you, ma'am. Any
Thank you.
questions?
So I normally don't comment, Mr. Chair, members of the commission, but I don't, Ms. Gillespie's complaint was not out of the order, not out of order, and a very reasonable request. Because generally speaking, when you look, and especially if you look at the signs that were included in the complaint, kind of standard campaign signs. But as an individual, when Ms. Walsh does that, she's not obligated to put a disclaimer on the materials when she's acting. So.
Any other questions?
I move that we find a violation.
We have a second to the motion. Motion that's been duly seconded to find no violation. I would just thank you very much, Mrs. Gillespie, for coming. No, you did the responsible thing.
I did. Indeed. Thank you, sir.
All right, all in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. No violation. By a vote of 7-0.
Dan, quick break.
I'm sorry.
We're taking a quick break. Just a quick break before we go to the defense.
Or go off the record.
Of course, we have. We're going to take about 5 minutes, right?
This is your stuff again. Only because. We'll look at the small things. Where we're at.
Yeah, it's just a meeting, let's take it right to you.
It started.
We had two different, we had two different ones, that just here, put it that way.
Oh.
Yeah, I stopped once.
Chris gave me a set, and I signed it.
What's that?
Yesterday, it would have been, I don't know.
There's two right in front of
Yeah, right here.
No, I've got a lot of top ones that I made. Those are actually top ones. I passed this one.
Very great.
They've been.
Okay.
All right. I want to make sure they're signed.
I signed the one that.
Was my signature on there?
No,
Oh.
mine was the first.
Mine was the first, and it went this way and that way. That's why I'm asking to make sure we have a complete set that are signed.
I do it for this time, just.
These should not be sent.
There was one that, oh, wait a minute, there was one that was placed in front of me.
Everybody had one. Everybody had one.
Okay, now, and then we're going to go down on the people section.
I'm glad I asked. All of a sudden, I'm like, wait, that guy.
I'm the memory to use too now, so nothing to fail.
This guy president.
So, I mean, we can very.
This guy.
It seems like everything is, you know.
They've had enough. They haven't.
Yeah. these are that stuff.
Well, you're being very much. Yeah.
All of the shadows. I still. Easy.
No. Yes.
Oh, of course. They could be just one by one. Always.
I like to say who's getting appointed. Yes, I know some of them, but
Yeah, because I'm telling you, like.
No, so that's what I think about. I realize that more than.
I'm still in a bill.
Yeah.
I started trying on there.
Well, you know,
Yeah.
You must have bring you up.
Let's say.
Oh, no, no, I appreciate it.
Okay, are we back on the record? All right, let's start with the group considerations. Mr. Rickers advised me that case 2021R-349, Mark J. Jacoba et al., that there is a witness present, is that correct?
Correct.
Yes.
Chairman, members of the commission, let me get my rest of the above. Yes.
So again, just for the record, I'm calling individually case 2021R-349, Mark J. Jacoba et al. And we're waiting on this.
This filter's slow. No. No. That's three. Mr. Chairman, members of the committee. This is a referral from the Weed Clark County Board of Elections for late filing of an semi-annual report to July 30, not filed until August 2d. a response was submitted. We completed and signed on the due date. Candidate intended to file it. The board's office is only a floor above the board's office. However, it got busy. Couldn't get down to the board. 30th was Friday. Report was filed on the next business day. My recommendation, this is the first time Mr. Colby has been before this commission. My recommendation is to find violation, but for good cause not opposed to fine. If the commission would like to hear from Mr. Colby, you can certainly do so.
Mr. Coley,
Thank you.
would you please, you're here as witness, I take on.
Correct.
Please swear the witness.
You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Go ahead, sir.
Thank you. My name is Mark Colby. I've been a lawyer for 34 years. I know the importance of deadlines. I became the Claremont County prosecuting attorney in January of this year. I filed the first 3 campaign finance reports on time. This one I had no contributions, no expenditures. I had it in my folder that day and I forgot to file it because I was busy. I thought about it Saturday and didn't feel real good about it over the weekend, so I filed it on Monday morning, the next business day. And I apologize. It's entirely my responsibility.
Thank you very much. Other questions, Mr. Colby?
I move that we follow the executive director's recommendation.
Do we have a second? Second. All right, we have a motion that's been duly seconded that we go ahead and find a violation, but for good cause, not impose a fine, and not refer the matter for prosecution. All in favor of the motion, signify by saying aye. Aye.
Thank you, and I appreciate it.
Motion
I'm
carries
sorry.
7-0.
My annual report is already prepared and I have no contributions and no expenditures. I'm gonna file it on January 3rd, the first day I'm eligible. Thank you. Have a great day. Take care.
Okay, we've got someone taking out here right now. This one here.
No, to this one.
All right, the next case we're going to call is under the $300 fine category. Case number 2021R-338, Lewis and I believe it's Caruso Jr. et al. I believe we have a witness. Is that correct?
We have the treasurer present, according to the signing fee, Mr. Chairman. This case involves failure to file various requested addendums for the 1920 annual reports to the Cuyahoga County Board. These were filed. I got that information at the Board of Elections. The treasurer submitted a response states the committee had a balance of around $300 for a 4-year period, starting after the last time they conducted the campaign. Money was being taken by the bank at the rate of $5 a month. And so he took it out of the bank, but yet the statement that was submitted, and the board accepted it in 2021, still reflects the same balance as the previous time. So I don't know if there was any explanation of what happened to the $5 a month that was identified in the statement. Anyway, based on the fact that the board accepted the file, there are prior cases, 2019 R440, 2016 R-194, 2014 R-128, and one back in 1995. So my recommendation is to find a violation, impose a $300 fine. Certainly the commission can hear from Mr. Weiss. So,
Mr. Weiss, would you please swear, Mr. Weiss?
You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, Mr. Weiss.
Raymond J. Weiss Jr.
Go ahead, sir.
As originally briefed, the last election that Mr. Caruso was in the 2017 period. At the end of that election cycle, there were approximately $300 that was left in the election account. The local bank was charging $5 a month, and over the next 4 years, that would have basically depleted all the money. So we had closed the account, had the money sitting in an envelope in my drawer at home. I was here in front of the board 2 years ago, and they identified the fact that that was a violation, and we paid a penalty for that fact. And looking to deposit the money back into a bank account in the name of the committee, and looking to do that in 2020, COVID hit, and weren't able to. First of all, we had to go into the banks and negotiate to get no fees, which I did find a local community bank that the money is now the same exact dollar amount is sitting in the bank. But it wasn't on deposit in a bank account in 2020.
So we weren't able to provide the bank statements in 2020, even though there was absolutely no activity in the committee's election campaign for the last 4 years. Right now, Mr. Cruz has been a councilman for 30+ years in the city of Brecksville. He did not run for re-election. He's retiring in November. So we're looking to basically close out the election committee before the campaign funds before the end of the year. So the facts and circumstances are pretty much the same as they were 2 years ago, except that the account wasn't reestablished in time that we could present the bank statements in 2020.
Okay, thank you, Mr. Weiss. Questions of Mr. Weiss? Thank you very much. Any other witnesses?
No.
Any other questions for discussion?
I do have a question for Mr. Ricker. I know typically what we do is we look back 5 years. And it seems to me that really we're talking about one violation in the past 5 years. Is that accurate?
Well, we did.
2020 was a correction of 19.
Correct. There is a 2019 case, the 2016 case, that was actually not decided until 2019. But it was for a failure to file, initially a failure to file the 2015 annual report. So I mean, within 5 years, the commission has acted on a couple of different occasions.
And in 2020, issued a fine of $200 and that was paid.
Correct.
But this is the same thing.
Yeah.
Right? It's the same violation. It's just coming up again because there was no report filed. Is that right?
There were delays in reporting, after, the board asked for addendums to the 2019 and 20 reports. And those were not initially filed, until after this referral was received from the board in August. I got a note from I can't remember exactly when, from the staff person at the Board of Elections about 3 weeks ago, that the reports were just filed, only in that kind of, that time period. Is it for the same, to a degree, some of the same set of circumstances? Yes. But there were reports outstanding throughout that period of time.
So the reports weren't filed, you said because you didn't have bank statements?
Correct. I provided on June 18th, I provided the bank statements to the Board of Election. I think his name is Robert Wells. John Fox, who was the previous one who originally sent out the inquiry, retired. So by the time I got to Robert Wells, it wasn't delivered until June 18th. And he had indicated by June 16th, he had already referred this matter to the Board of Elections. So we were 2 days late in regards to providing the bank statements that related to previous periods, but he had already referred the matter to the Board of Elections.
But had you filed any reports for those periods?
Yeah, the reports were filed. They showed the $303 at the beginning of the year, at the end of the year. They asked, the follow-up was to ask for bank statements. I couldn't provide the bank statements, and we provided the bank statements after the fact, but those bank statements weren't opened until spring of 2021.
And did the bank statements that you filed actually reflect the amount that you reported?
Yeah, the 303.49. The money's still in there today. It's just, we want to close it out because the account's no longer needed. He's no longer active then.
Just as a point of order, on November 29th, I received a response from staff at the Cuyahoga County Board of Elections that on that day they received a copy of the letter that was sent to us, based on which I made my recommendation. The last time we ran was in 2013, when the balance was $303.49. That balance remained the same through the 22 annual without the commission bank statement. Now included in this letter to request the removal of the referrals of bank statements beginning in August of 2021. The letter does not clarify when the original bank started taking fees. How does the balance stay the same if the fees were being taken before he removed the money illegally? That says illegally, but I'd say improperly from the bank, placed it in the shoebox. The board says the referral stands on the basis the monies were removed and not placed in a secure bank account for years. So that's what I received from the Cuyahoga County Board of Elections, isn't related to this matter.
Okay, so I have a couple of questions. When You said he last ran, you said he last ran 13, but I thought.
That's
17.
that was what's included here. It could have been
Okay,
17.
so it's 17. And when the last report was filed before the money got put in the shoebox, what was the balance? $303.17.
That's what was reported here in this, and that's my understanding, yes.
So when
That's correct.
took it out of the bank and, you know, fees stopped and we took it out of the bank, but it held it as cash. It was $303.17. When they reopened an account, it was $303, probably not cents.
49 cents.
49. I'm sorry, I wrote it down on. Can't read my writing.
That's not quibble over 22 cents.
So when they had reported things, they take it out of the bank to stop the fees. Hold it as cash is $303.49. They negotiated with the bank to take no fees out. Deposit in the bank for $303.49. File the reports, but can't get bank statements in the time that they're holding it in cash. When they can finally get bank statements, the bank statement matches the last amount. So really what we're talking about is a violation for holding cash and not having a bank statement to verify, or am I missing something?
Well, and I think that it was, I'm looking, the search can make finance reports at this point.
Okay, take your time.
And to your point, they paid $200 fine for holding.
Cash.
2 years ago for the same.
The same cash.
Yes.
Same cash. So it's been delayed and had a intervening pandemic. Yes.
Okay, the 15 annual reflects $303.49.
That's the number we heard.
15. 16 annual reflects the same. Okay, so I guess it then becomes a matter of, okay, if at some point bank fees were being taken out, which led to the taking money out of the bank, where are those reflected?
Were there bank fees though? He said there weren't.
Back then, PNC was beginning to charge, originally, they weren't charging fees, that only had $300 in the account. They said, we're gonna start charging you $5 a month. Well, in 4 years, it would depleted all but $40. So I took the money out of the bank
He took it
to
out.
avoid the fees.
Avoid the fee.
There weren't fees. There were going to be. fees.
They were going to implement fees if I didn't have a balance of $1,000, and the account only had $300.
So he takes it out as cash and you tell him you can't do that. So then he negotiates to find a bank who's not gonna charge him. He puts the exact same money in and isn't charged fees.
Since 15, it's been
Big money.
341.
Even though there was an election fee. I'm not sure how that is, but okay.
And they've already taken $205 fine, they're taking money out, and that's the fact that I move that we find the violation of a good cause, not impose a fine for this or for prosecution.
I second.
All right, we have a motion that's been duly seconded that would find the violation of for good cause, not impose a fine or refer for prosecution. Further discussion by the commission. If not, all in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries 507-0. Thank you very much, sir.
Thank you.
You had one other.
Case number 2021-371.
Friends of Marion D.D. et al. Any witnesses?
Yes, ma'am.
Where are we gonna find this one?
It is in the
Under $100.
fine category.
Thank you.
Mr. Chair, members of the commission, with well received from Marion County Board of Elections. I actually sent a copy of the referral and the response to you all a couple days ago. Talked briefly with Ms. Omenauer, who indicated she would be here. There are a variety of things included in the referral, all of the response, I believe, responded to all of them. The primary basis for my recommendation to impose $500 is the fact that there were a couple of contributions over $100 received in cash. Based on the complaint and the response, it appeared that everything else in the complaint was referred to. There were a couple of things included in the allegations relating to Title 29 violations, not our jurisdiction. We can't deal with those. I didn't send it to you all, but we actually received a letter from the prosecutor's office concerning those circumstances in which they found the least forward. There were also some included in the complaint, some assertions related to the Ohio Administrative Code. But again, this commission doesn't have jurisdiction over those provisions, even though they are extensions of the statute. So it appears that the reports submitted by the committee were sufficient and responded to all the items included in the board's request for addendum. Again, included in there were admissions that there were contributions received over $100. And so I find that to be a violation, and that's the primary basis for my recommendation. The commission would like to hear from Ms. Obenauer. I can certainly do that.
Peggy, would you please swear this?
Yeah. You swear to tell the truth, whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, ma'am.
Good morning.
Do you have any statement you'd like to make?
I do.
Please go ahead.
My name's Jean Obenauer, and I've been treasurer for the Friends of Marion DD since its inception, and have done previous candidates and different versions of those. And doing the levy was a little different for me in my capacity. So when we started working on this, I relied heavily on our board in Marion to assist us, and that just didn't happen. So a lot of the violations that they had, the day we filed this report, I told them that we had questions, we needed to work on this. The fact they waited 11 months and had turned us into this violation so much later that we could have answered all of these things. And we finally got together in June and responded with everything and filed an amendment. I'm assuming they are supposed to file the amendment with you to take care of these things, or if I'm under that misunderstanding, my fault, but I thought it was all taken care of. So that's one reason I was concerned on fact. The two violations that you're referring to, we had a fundraiser in an evening that had raffles, and it had about 7 different versions of how people could donate. At the end of the evening, we found one woman who gave $102 and a gentleman gave $137. And by the time we got the reports and everything, re-verified that we weren't even supposed to take more than $100 in cash. It was 11 months later, and we didn't have the cash to refund to these people. And I offered to put it in myself. They refused that. They said that was a violation. So I wasn't sure where to go with it. So we got affidavits from the 2 people who got more, concerned with the fact that they weren't thinking they were doing anything wrong. They were donating to a cause they believe in. So they assigned the affidavit that's in our packet that showed that that is where it should go and why. And if we're in violation, we didn't want to hold them responsible for it. The fact that some of the rules were just unbeknownst to me. We've tried to keep up on as everything we can. We have serious concerns with the Marion County Board of Elections, which I guess isn't the time and place to do. But a lot of the issues that we're having are coming from this. And if they were a little more on top of everything, we wouldn't be here wasting your time or anyone else's time to be able to go through the facts that should have been at least taken care of properly in some semblance of time from 11 months from when the report was filed. I'll stop there.
Those lines.
See, all calm and.
Any questions of this one?
Thank you, sir. Is this a repeat violation, Mr. Ricker, or is it you're fine based upon the fact that there were 2 violations?
It's based on the fact, and I thought your response said that the one person contributed like $285 or something like that.
That's what I thought I had read.
Okay, 285.
Okay.
Sorry.
That's the primary basis of the record.
And then 100 of it would have been allowed, but the 100 and anything base over would have not been. And we just didn't have the money. We used it all on the levy campaign, and we didn't have the money to refund to them. And that's one of the portions.
But you were unaware the cash contribution in excess of $100.
Yes, I was not aware of that. And by the time we got the information from the Board of Election, it was long past the fundraiser. And it's in, your website, 42 page or whatever, down on the bottom of whatever. And when she prints it out and gives it to us, highlight says you should have known this. I've known that Election Bureau and been doing this for 10 years. They know that I've run with different campaigns, different judges. I've come down here for the campaign classes for the judges on how to do things correctly. Did not realize on the Levitt campaign that there was differences. They could have provided that information to me. They knew about this fundraiser. They knew we were doing it before we had it. Some of the people in that building were at the fundraiser. No one had instructed us to go from there. I was not present at the time, but I had enough information for the people that I trust very heavily at that agency to say, if there's a dime donated, I wanted to know for who. We took in $24,000 that night. We were able to account for all but $88. And $88 we had extra, and I still can't put a name on that part. So I didn't think we did too bad of a job on an 88-page report to try to make sure that we did all of that. So the fact we were disconcerted at not getting some of the instructions, once we knew where they were, I was able to go back and amend the report to be able to complete whatever I needed to do.
Thank you. Any other questions? Mr. Richter, any other additional thoughts? We have a motion.
I move that we find a violation with a post a fine of $50.
We have a second to that motion. Further discussion on the motion? Find violation and post fine $50. All in favor of the motion signify by saying aye. Aye. Opposed, same sign. Motion carries by vote 7-0. Thank you very much, Mr.
Thank you.
All right, let's go back to, is there anybody else here on any other case? Yes, ma'am.
I'm Tara Dyer, right after the Friends of Marion DB. 337.
Item 40.
You said Tara Dyer?
Yes.
Yeah, item number 48, it's under the $25 a day category. Case number 2021 R-372.
Got it. Okay. All right, case number 2021 R-372, Tara Dyer et al.
This case involves a late filing of a series of requested addenda, failure to file a complete and accurate statement of 351713. I received an email yesterday from your board, I think it was yesterday. Sorry for the delay.
I have copies of the update that Cindy Price and Brian Blair sent. They also gave me
Just a
copies.
second, ma'am.
Okay.
I'll just, do you want to
Okay.
swear the witness? So that-
Do you swear from tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ma'am, just one for the record, would you please state your name?
My name is Tara Dyer.
Tara? Go ahead. Did you have something?
No, I think he's looking for referring to an email that Cindy Price sent. She submitted update number 2.
Yes, it was on Tuesday, actually, at 4:30. And the statement included in the, what was submitted. Please see the yellow highlighted reports below. All reports listed below have been submitted to the Marion County Board of Elections, and the office is now satisfied with all highlighted reports, as well as the 2021. Oh, okay, I apologize. I misunderstood the referral to say that they still had outstanding items. That's why they were highlighted. Okay, so this would have changed my recommendation from $25 per day for failing to file those reports to, without a response, a recommendation to a fine of $50 or $100, since there was no response. With Ms. Tyler here present, we can certainly hear from here, and the commission can make a determination as to how it was to proceed.
Okay. The Board of Elections, I don't know if it's beat on Marion Board of Elections Day, but I digress. They should have sent an updated reflecting that I have also submitted all of the required documentations. And in the letter, it said that our office has suggested that they audit each one of those before we move forward. So in my statement, I don't want to, I know a lot of people are concerned that COVID protocols and mandates may have hampered a lot of these situations, as well as the recommendation from the Board of Election as far as audits are concerned. But my treasurer had an adverse reaction to the COVID shot. He also had gout. He had heart problems and the inability to meet face to face and do the audits as required at the office. Sometimes their offices were closed. And I feel that, well, you guys know that if you make one mistake on one, it's a ripple effect. So that's why, it is very important to get the audit so that you can proceed. So the Board of Elections did, I was in there as late as yesterday to get information so that I can bring to you. And I also did have the statement, my statement, but was unaware of how it should be filed. And when I asked the Board of Elections, their response was, once these things are turned over to this body, they don't know what happens. They didn't even respond when I asked them where this location was. Thank God you guys put it in your letter, but I was still in Gahanna this morning because my GPS took me there. So not only do I get the pleasure of being in front of a commission, but I'm also in Gahanna at Wendy's. I'm like, okay. So welcome to Columbus. So
Carroll's in Lake County.
So, on top of all those wonderful things, I taught for 35 years. I've never had any integrity type things. I was a teacher. So, I am staunchly aware of deadlines and adhering to those deadlines. So I feel awful that I'm in front of this body today and would love to have a resolution to this so that I can definitely sleep at night. So thank you for this. And I do apologize. And on behalf of my treasurer, we normally are very good at this. And we will not be in front of your body again.
Thank you very much, ma'am. Questions?
The issue is resolved now.
Yeah. I move that we find a violation, but for good cause, not oppose it, find and refer this for further prosecution.
Second.
All right, we have a motion. It's been made and duly seconded that we find a violation, but for good cause, not impose a fine, nor impose for prosecution. For the discussion, all in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0. Thank you very much.
Thank you. Have a great day.
Safe travels. I hope you have.
No, my GPS, I know how to get home. I'll follow them.
Oh, you can't get there.
Okay. All right, any other witnesses, Mr. Richter, for any cases?
Just go straight up the street.
All right, let's go back to the top of the group considerations then. Again. In the good cause category, case 2021R-348, 2021R-352, 2021R-354, 2021R-357, 2021R-358, 2021R-363, 2021R-364, 2021R-367, 2021R-369. All right, do we have a motion? Excuse me, strike that, I apologize. Mr. Richter, do you have anything to say?
No, I didn't.
All right.
I move the recommendation of the executive.
All right, do we have a second? Second, we have a motion that's been duly seconded that would follow the recommendation of the executive director, which would be a fine violation, but for good cause, not impose fine nor refer to prosecution. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0. Next category, case 2021R-346, 2021R-347. Mr. Richter.
there were two different referrals made by the, in the Stanton County Board of Elections, but that's not right. That's for Ross County Board of Elections. Based on complaints that they had received from individuals, they concerned whether there were disclaimers on materials and the fact that a pre-election filing was not made. The Commission received a response, which I've outlined for you from Mr. Wallach. He was a write-in candidate, indicates he was confused by the wording of the statutes that talked about persons whose name appears on a ballot is required to file a pre-election or post-election report. Well, his name didn't appear on the ballot. He was a write-in candidate. So I understand his confusion. Alternatively, that doesn't necessarily mean he isn't still obligated to file a report. And in looking at his campaign finance report that was submitted, the very first receipt, the very first contribution he received in September was for $5,000, which would presumably make you obligated to file a pre-election report. And also he indicated in his statement, he admitted that his first mailer did not have the disclaimer, but that all subsequent mailers, even though they were alleged to have not included, did have a disclaimer. He presented that as well as part of his response. And so my recommendation is to consolidate these two matters, find a violation, but for good cause, not impose a fine, or for a matter of further prosecution. This is the first time he's running. He was running as a write-in candidate. He wasn't necessarily aware of all the circumstances that apply to him.
Thank you, sir. Questions of Mr. Richter? If not, I'll entertain a motion.
So moved.
Give a second.
Second.
We have a motion that's been duly seconded that would consolidate these two cases, find the violation, but for good cause, not impose a fine, or refer to prosecution. All in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Next category, case 2021R-340, 2021R-351, 2021R-353, 2021R-359, 2021R-360, 2021R-362, 2021R-368, 2021R-376, 2021R-377, 2021R-378.
These cases all represent persons who filed their reports. They were late. A response was submitted, but they were also, as I reviewed the materials, not filed within a day or two or shortly after the due date for filing. They were filed much later. And so my recommendation on each of these matters is for the commission to impose a fine of $50 after a notice violation.
Thank you, sir. Questions of Mr. Richter? If not, I'll entertain a motion.
So moved.
Motion, we have a second.
Second.
Motion been duly seconded to go ahead and find a violation, but propose a fine of $50. All in favor of the motion, signify by saying aye. Aye. Those same sign, motion carries by a vote of 7-0. And the next category, case 21R-334, 2021R-366, 2021R-375.
These matters were failure or late filing cases where the reports were filed, but no response was submitted to the commission on which I could make a recommendation. So therefore, my recommendation is to find a violation and impose a fine of $100.
Questions from Mr. Richter?
So moved.
Motion, we have a second.
Second.
We have a motion that's been duly seconded to go ahead and find a violation, impose a fine of $100. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0. Next case, 2021R-342. Mr. Richter has recommended reconsidering all outstanding matters, vacate the previous imposition of the per diem fines, consolidate the cases with case number 2021R-342, find the violation, and impose a fine of $200. Mr. Richter.
This is a little bit of an interesting one. If you look at the case summary that was sent to you, the commission, the respondent had a bit of a checkered history before the commission, and a number of times where we made findings, imposed per diem fines, never not necessarily addressed. Well, there it is. On December 2nd, the commission received a check from his right now for $250. Then if you would look at case number 2020R-053, complies with the finding by the commission there that we would reconsider a matter if she paid $250, which she did. And so, under that set of circumstances, and getting the relative convenience of this case being back before the commission, I decided that the most appropriate thing to do was to reconsider that case as well as 2019 R160 and 2021 R044, which we proposed pretty fines. Consolidated with this case, and then if you look at the ICW, the judge reflects it after losing her election in 2017, the disappointment that followed, she couldn't do anything campaign related. She had then subsequently moved, change residences, and the COVID situation arose. But anyway, she's now gotten all the reports in. The committee has been terminated. And she wants to get all of this resolved. And so the fact that there were so many outstanding cases and that this matter was still outstanding at the time the commission took it under consideration, I'm recommending that we, again, as it says, reconsider all the outstanding matters and vacate the previous imposition of purging fines, consolidate those cases with this case, find a violation, and then impose a fine of $200 because of the outstanding matters.
Is that fine of $200 an additional $200 or accepting the $200?
No, it is in addition to what we have already received. Which is a little bit out of the ordinary, again, considering the number of outstanding cases, that's why I decided to do it, so.
Well, and I'm wondering, just out loud, if what we should do is consolidate all of the other cases and accept the $200 fine and keep this case separate and impose a $200. Don't know, it seems to me like that's really what you're doing, because she already paid the fine in the other ones, right?
Yes. Well, she paid the fine at one, but got it back.
But she paid the fine at one, but that was for.
But we don't have to consolidate all those matters with this one. We should reconsider them, essentially accept the fine.
You're talking about reconsidering everything from since 2016.
Correct.
Since the committee closed, that lets us wrap up everything.
Bundling them all up here.
Yeah,
and then
okay.
get rid of them.
So accept the 200 and post 200
Correct,
and put them all into one case.
correct. That's my recommendation.
Tidy things up with one nice neat bow.
For Christmas.
Okay, for Christmas.
Do you have any other comments, questions, or do we have a motion?
So move.
All right, thank you very much, Mr. Mullin. Do we have a second?
Second.
The motion has been duly seconded, then we'll go ahead and follow the recommendation of the executive director for the discussion. If not, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0. Next case, 2021R-361. Mr. Rickman.
This is, there was an outstanding pending matter, 2020 R-361, the commission had decided. And so, we did get good service here, even though it doesn't, we didn't receive, there's no reflection of service, but we did receive a response from the respondent about the candidate dropping out of the campaign or the race. By the time the election occurred, he forgot about the open campaign committee, but now all reports have been subsequently filed. It is in compliance. And so I thought it appropriate to consolidate the outstanding case with this case and make one particular finding. My recommendation is obviously by the violation and impose a fine of $200. I'm glad to answer any of the questions you may have.
If not, I'll entertain a motion.
So moved.
And we have a motion to follow the recommendation of the executive director. Is there a second?
Second.
All right, duly seconded. Further discussion? If not, all in favor of the motion to consolidate the case number 2021R-339, fine violation and impose a fine of $200. Signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0. Next category would be case number 2021R-336.
This matter is still outstanding. We did get service on the respondent. There was a previous case that was also pending outstanding, so I'm recommending that we consolidate those matters. Find a violation, impose a fine of $25 a day, but give the candidate and committee the opportunity to have the matter reconsidered if the reports are filed.
Comments, questions of Mr. Richter?
So moved.
We have motion, do we have second? Second. We have motion been duly seconded. We'll go ahead and consolidate this case with case number 2021R-086 and impose fine of $45 a day with reconsideration option. All in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 7-0.
I still feel like I need to raise my hand.
Yeah.
Case number 2021R-335.
This is a case as well as it's a case where we've gotten service on the respondent. No response has been submitted. The report is still outstanding. There is a prior case. No, I'm not consolidating here. There were prior cases decided in which the commission imposed a fine of $25 a day. We gave the opportunity as matter reconsidered. That has not been dealt with. My recommendation is to find a violation, impose a fine of $25 per day. Give the candidate the option to have the matter reconsidered with as long as payment of $250.
Questions of Mr. Richter? Motion.
So moved.
We have a second.
Second.
Motion has been duly seconded. We follow the recommendation of the executive director. Discussion. All in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Following cases have been continued for service. 2021R-330, 2021R-333, 2021R-337, 2021R-339, 2021R-341, 2021R-343, 2021R-344, 2021R-345, 2021R-350, 2021R-355, 2021R-356, 2021R-365, 2021R-374, 2021R-379, 2021R-380. Next category, continue upon request of respondent. Do we need any action on that?
No, just you have the ability to continue.
All right. Following cases have been continued upon request of the respondent. Case 2021R-331, 2021R-332, 2021R-370, and 2021R-373. And that concludes the group considerations. Moving on into the hearing part of our agenda. Next case is case 2021G-019, Hicks versus Freeman et al. I'm going to go ahead, as I've done in the past, recuse myself. Turn the gavel over to the vice chair. I'd like to reflect I recuse myself. I have excellent thing right now.
Okay. No, we're going to need you to sit up. Yeah. Mr. Vice Chair, members of the commission, based on the activities at the commission December 7th meeting, I prepared a decision and finding on behalf of the commission, which I circulated to everybody in advance. Not hearing that anyone was, either displeased or had any other issues with that writing. I will give Mr. Hughes credit for looking at it for typos, et cetera, and finding a couple of things which I corrected and then subsequently circulated a revised version of it. It is here and available at the commission's meeting of November 18th. We took the option of giving ourselves 30 days in which to come up with a decision and find. In this case, presumably we'll have. This is the last meeting prior to that date. I'm not sure that there's anything else I have to add at this point. I've written and circulated it. We did receive a submission from Mr. Bry yesterday, which I forwarded to all of you. You can comment on it as you wish. The commission would like to hear further from Mr. Bry. He's obviously here. I certainly would recommend that the commission go forward based on previous actions and the writing that it is present, but, up to you, Mr. Chair, as members of the commission, as to where you wish to go.
Okay, any comment on the, appropriate course of action? Taking, as the executive director summarized, we do have the option now of adopting the signing off on the written decision and issuing that as our decision as to the item.
Well, as I had seen the materials submitted to us, it seemed to me that there had been a request to terminate the committee, but I had not seen any information that the committee was actually terminated. And so I think it would be appropriate to dismiss, a motion to dismiss and adopt the findings that we had all come to throughout the course of our deliberations.
If I may speak to that, Brian Hickson, Secretary of State's office, said it has been terminated.
Okay, thank you. Any other comments regarding that?
I think we should take action on what we had agreed to on December the 7th and really memorialized in the document that Phil prepared. So I think we should take action on that.
Are there any procedural reasons why we would need to even address this particular motion prior to issuing our decision? I don't see
Mr. Hicks notified?
Yes, yes. He actually responded by email. He had a couple of responses by email to me. I honestly glanced at them, but I didn't pay a great deal of attention to
What
them.
was the
Yesterday at about 2:00, something like that. 2 o'clock, somewhere in that time. And I could give you the exact time, but
I don't know.
But we would still be able to I just want to clarify here, we move forward with this decision, we would still be able to address the motion at a later time.
Yeah, go on, sir.
I mean, because there's multi parts of it, it's not.
341 is when the submission was received. The notice of termination of response and motion dismissed. Or termination of responding committee. Excuse me.
May I be permitted to speak to the motion, or is the decision that I will not be permitted to speak?
I'm sorry, go ahead.
May I speak to the motion or not?
When you say speak to the motion, are you speaking to the substance of the motion or to what I raised about should the motion be addressed?
We have on the agenda today and under service and reasonable notice.
I agree.
I think those are all problems. I don't think we should address it if it's not on the
You
agenda.
closed the hearing.
Right, we did.
I did.
But there's nothing improper about notifying the commission of new facts, such as the termination of the committee, that between the closing of the hearing and the decision, which has not been rendered, make its jurisdiction
We're not wanting to
problematic.
speak before this commission. Well, Mr. Hicks doesn't have the opportunity to respond,
Right.
nor have we had the opportunity to really review it. I really think the way you approached it is completely unfair and violates due process.
Well, I believe the same thing about the way you have expressed yourself last Tuesday. So we've all been disappointed. The undisputed facts were my client talked to 5 people, and you said he made no efforts to find facts out. The record reflects what it reflects.
I move that we adopt the opinion drafted by Mr. Recker as it relates to our opinion in Hicks versus Freeman matter.
Second.
All right, there's been a motion, second. Let's do a voice vote.
Oh, you get a roll call, but roll call. Okay, I'm just noting here. Ms. Cunningham,
Yes.
Ms. Tavares,
Yes.
Ms. Kaufman,
Yes.
Mr. Brower,
Yes.
Mr. Norman,
Yes.
Vice Chair Baker.
Yes.
The motion passes 6-0.
Will the commission be scheduling the motion for a later discussion at a later hearing?
We've made our decision in the case. I mean, the commission has been under advisement on the 18th. Met on the 7th to discuss how it wanted to proceed. Directed me to produce this material, which I did. That
We have the
summarizes those
obligation to
findings.
decide it today, right? Or
And we have the
tomorrow.
obligation to decide today. I believe that there's a result. So
And just for the point of clarification, what would be the respondent's next step procedurally insofar as this decision?
once
To
the
appeal
commission,
or what have
once the commission finalizes this decision and sends out its determination letter, he would have 15 days in which to file an appeal, revised code chapter 119 appeal.
What I would say is that the entry, the notice, which invokes the 15 days, is in fact, the entry of the commission. The vote today is like a decision, an oral decision of a court, which later reflects itself in a judgment entry, which can be subject to appeal. What that also means is before the judgment entry is issued, the motion is still something that could be considered by the commission, if it chooses to do so.
Thank you.
Commission,
I think
the
commission made its
certainly
decision,
contact me.
has made
This
a
matter forward.
decision on that particular issue regarding the submitted motion.
What's next, Mr. Chairman?
I'm good, Mr. Kreitz, yes?
Yes.
Mike, ready, you can return to us. I'm unaccustomed to that kind of revenue.
There you go, now.
I think I missed the light.
That's money. They like their wax. So they go by the time they have their lunch.
So, all right, are we ready to get back on the record? I do this.
Yes. Yeah, 22. Hyatt, who was it? He's 19 and then. Yeah.
All right, calendar advisory opinion. Let's, Don's already here. Let's go ahead and take that one first, if that's okay. Donald J. McTighe, consideration of transition fund circumstances, case 2021 ELC-06, advisory opinion, I should say.
Mr. Chair, members of the commission, you have, previously I provided everybody with the request letter that Mr. Mr. McTighe's office had provided.
Our fault, Dave.
Go ahead, you can say it.
He's in your head.
As well as
I don't understand.
the opinion that we have here before us. My only concern with taking them out of order is if there is a problem with any of the previous ones and you don't want to issue, you got to change the number, which is not the end of the world. We can do it, but just say it. Anyway, Anyway, it has been circulated to everybody. You guys haven't necessarily commented back, not a big deal if everybody likes it. Mr. McTighe, I will let you know, Mr. McTighe had a conversation last night about this in general. He forwarded along to me some suggestions, possibly, as it related to syllabus items, I think just 1, 2, and 4. After reviewing them, I got back in this morning and just, as a courtesy said, I appreciate your suggestions, but I'm comfortable with the way it's written. None of the commission members has commented back to me with regard to changing anything. And so therefore, I'm inclined to go forward with what we have here before us currently. I don't know if the commission would like to hear from Mr. McTighe further on this. We certainly have an ability to do so. Okay.
Mr. McTighe?
Thank you, Mr. Chairman, members of the commission. I told Mr. Richter this in an email this morning that I would be happy to answer any questions. I wasn't going to press for the adoption of my suggested changes, but if they came up during any questions about the draft that you have in front of you, that I could address things at that time. I had originally contacted Mr. Richter last night just to make sure that I understood the thrust of his draft opinion, and which, by the way, was also my opinion. As ultimately, we kind of use different words, but I wanted to make sure.
Should we be concerned about that comment?
Well, I wanted to make sure we were kind of on the same page, because ultimately I'll have to, explain to the client what this means, what this opinion means. So, and I think we're on the same page, but I was asking for a little more clarity here or there. But again, it's, I'm really here just to answer any questions that you have about our request.
Any questions of Mr. McTighe? Thank you, sir.
Okay, thank you.
All right, Mr. Richter, anything further?
No, I don't believe so. I feel like I have responded to the question posed appropriately on behalf of the commission, trying to give some clarity to the issues about which the opinion was posed. And I believe that I have done so in such a way that it makes it a little clearer as to how it all supposed to work. So I'm comfortable with the writing as I have done it. I guess my recommendation though would be, I have it identified as 2020 ELC 06. We change it to 2021 ELC 03 if we want to take it now and move forward. That's not that big. That's fine. I'll change that.
Even as 06, just move to adopt it as 06.
Well, as I said, that's not a problem for me, but it would be strange if we don't take any of the other ones.
Well, we can do a post motion after
Right,
that,
exactly.
fix it.
Just like,
Okay.
we'll let him present, say what he needs to say.
Okay.
I mean, that's the only concern I have is
Anything further then?
kind of a procedural thing.
Housekeeping.
Okay. Oh, Mr. O'Brien's going.
He's going.
Okay.
Okay.
See if he had it.
All right, we're going to defer right now on any action on that. Let's move then back to 2021 ELC-03.
03, 04, and 05. As we briefly discussed at the last meeting, when they were briefly addressed, were all kind of brought to the commission's attention by one means or another. 03 deals with the issue of how cryptocurrency essentially should be reflected in campaign finance reports. When I wrote it, I relied to a certain degree on a Federal Elections Commission opinion from 2014. As we addressed this the last time, Ms. Cunningham in particular questioned with the last paragraph on page 2 that preceded the actual, finding by the commission, which was the last paragraph. And I did change that to hopefully make it a little clearer in terms of, some of our concerns. And so it now reads, lastly, in order to be used by the campaign committee, any form of cryptocurrency would eventually need to be turned into a cash equivalent, dollar. As the value of the contribution was accurately reflected in the campaign finance report when it was received, upon exchange, the amount of the cryptocurrency will be reflected in the campaign finance report as an other income entry. When that exchange is completed, any costs involved in the exchange must be shown as an expenditure for the campaign committee. That allows it to be, if it goes up or down in value, the other income shows how much it actually is, and then the actual cost of the transaction is reflected as an expenditure. I think it explains it a little more clear.
It does. And I was concerned too about contribution limits and how that applies based on date you receive.
Okay, correct.
I appreciate you following up on that. Felt like it was a good
Not a problem.
clarification.
Not a problem. Thank you.
Any other comments on 03? What about 04?
Sure, we can just go ahead and do them all. 04, find it. Okay. There were questions and concerns that were brought to the commission's attention with regard to how PayPal is being used. In particular, this came out of a circumstance that the commission was generally apprised of, I think it was Summit County, where the person was accepting contributions into a personal PayPal account and transferring them over to the campaign committee. And essentially what we're saying here is, no, you can't do that. That's, a contribution to a personal account. And so here, what we're essentially just saying is, if a campaign committee is going to utilize a Venmo account, it has to do so to a campaign committee's Venmo account and not to any kind of a personal account and then transfer money or think that that's okay. Because, having a contribution go to any kind of personal account is improper according to statute. So that's the essential finding.
Just out of curiosity, does anybody know, does Venmo have an accommodation for entity or business accounts? Or is that purely personal or kind of depends bank to bank?
I don't know the answer to that because I don't have one.
I mean, that doesn't change, what I'm saying about the rule, but it doesn't matter.
No, you get a report every month. Is that what you're saying? Like, do they have reporting that you can?
No, what I'm saying is, some of these banking products are, the bank in particular, are only available on personal individual accounts and not available on business accounts. I mean, obviously, PayPal's not like that. PayPal, there are PayPal business accounts.
I'm pretty sure Venmo has business accounts as well.
Okay.
And you said originally PayPal and then referred to Venmo. I'm assuming you've used it interchangeably here, Mr. Director?
The primary concern was related to Venmo. But yeah, I think it could be easily applied across to any of those types of.
The syllabus is peer-to-peer payment system account.
And I was only.
Exemplified as a Venmo.
I was just doing it for the record, because when he came out and started talking about 2021 ELC 04, he was referring to PayPal, but the caption is actually Venmo.
Right.
I think it's just a memorialization of what we've already held.
I think it's the same concept.
Yeah.
Okay. Any other questions on advisory opinion 04? All right, 05.
This was a situation that was brought to my attention, honestly, after a discussion with staff at the Secretary of State's office. And then in looking into the situation, it was prompted by I guess I'd say a magazine article and conversation that I had there, because it was a decision by the FEC that could be interpreted as allowing foreign nationals to make contributions to ballot issues based on the way the decision was made. And I forwarded to you the article that was brought to my attention and the decision and where the decision came from. And this opinion, and it was suggested in the article, and my discussion with staff at the Secretary's office would necessarily be a bad idea to have the commission make a statement that, just says in Ohio, and relying on 3517-13W, which talks about foreign nationals and that foreign nationals are prohibited. Because I guess there are some states where, again, kind of going back to the article, there are some states that don't have a provision like that anywhere in their statute. Whereas at least Ohio had that statute, and so I think it's appropriate for the commission to say we're interpreting that to also apply to ballot issues, whereas it kind of more speaks directly to like candidate campaign committees. But essentially, it's a prohibition in the statutes for foreign nationals participating in a local election.
Questions to Mr. Richter?
So that's where that one is.
Going back to Otto, your question about Venmo and business, I just looked it up and it said, can I use my Venmo or my business account? It says, once you set up a Venmo business profile, you can start to accept Venmo transactions for your business. So, thank you.
Thank you. Well, as I was going to say, I originally looked past it. I was looking at some other things, but I looked at the Venmo website, and at the very top, it says Venmo, so send and receive, pay with Venmo. Venmo for business, so, there are, accept Venmo payments, business profiles, et cetera. So, it would appear that, that type of an application is appropriate.
Okay. Are there any discussions on either 03, 04, 05, 06? Is there any reason why we can't take one motion to consolidate approval of all?
Not, and I'm aware, Mr. Chair, no. I mean, we've
Then I'll entertain a motion that we approve advisory opinions 2021 ELC 03, 2021 ELC 04, 2021 ELC 05, and 2021 ELC 06, and authorize the chairman to sign each. We have a second.
Is that you moving, you second, did you second it? Okay. I did something. I did not open my mouth that time. I wasn't trying to obligate you to do so.
I did not open my mouth that time.
All right.
I just heard a shh, and I was like, okay.
We got a motion that was duly seconded as to 03, 04, 05, and 06. Further discussion? If not, all in favor of the motion signify by saying aye.
Aye.
Opposed, same sign, motion carries. Thank you, Mr. McDye.
Thank you.
All right.
The unsigned copy.
I will have the.
Well, you emailed me it or it
Oh.
changed.
Sign a copy on the website.
No.
By the end.
A signed copy will be available.
Oh, okay. Yeah, that's fine.
No.
The only thing I'm saying, there may be a follow-up request for clarification on, on a couple issues in terms of what the client may want to do.
Okay.
Just so we make sure we're in compliance.
Okay,
Okay.
not a problem.
Thank you.
Thank you.
Happy holidays, everyone.
Happy holidays.
All right, moving on to the final category of the business. Our next meeting is January the 13th, 2022. Mr. Richter, do we have anything else?
There is one other thing that Mr. Hughes and I, if you would like to take that. What's to the box over there?
Why don't we do that right after the meeting?
Yeah, that's the only thing other left to do, so we can adjourn the meeting.
Hey, I want to wish everybody a Merry Christmas, a Happy Holiday, or however you may celebrate it. I want to joke from a personal standpoint. Service on this board with each of you, I'm very thankful to have the opportunity to serve with you. So there's a lot of gratitude that flows from me. Thank you very much.
Thank you,
family.
Chairman.
Happy holiday. All right, entertain a motion then. We have a second. All in favor of the motion, signify by saying aye.
I've got 3 days in the stage, so hopefully tonight.
All right. How's everything at home, okay?
I mean, we're in rehab, so hoping that, oh my gosh.
Do they have any idea about what it's going to take?
What they said yesterday, hopefully we will get participate today. I've gotten text that.
Yeah, let's go off the record.
Yeah, we're.
In line. So we went to the Lima, which is
Well, that's better.
So it is very,
easier.
yeah.
Yeah.
I appreciate it. Generate that to me.
But, yeah, the thing about it is, it was always, he always was talked like